All right. It has to have all four of these to maintain the joint tenants. You cannot have anything different. Now, here's a kicker and the big difference between the joint tenants and the tenants in common. Joint tenants have this special thing called right of survivorship. Right of survivorship. And a lot of times on the title you'll see JTWRS, which stands for What Would Jesus Do? No, wait, those are the wrong letters. Joint tenants with right of survivorship. In this example that I'm using where it's Maggie and I and Sing, when one of us dies, their portion goes to the remaining two. So the three of us cannot, listen to what I'm saying, I want everybody's eyes up here so you understand, watch my lips move, cannot sell our portion. We can't give it away. I can't leave it in my will. None of it. Not like I could at tenants in common. Joint tenants has right of survivorship. I die, my portion is divided amongst the remaining members, and their scenario where there's three of us, one person dies, now there's two, they each own how much? 50-50. And then one of those die, last person owns 100%, which is called what? Severity. Several. They now own it in severalty. They win the game. All right? This is like every episode of Matlock, where they used to kill their family off to get to the house, right? That's what this is. So right of survivorship is the key element in joint tenants. When I die, it does not go into my estate and I will it to my children. No, it goes to the other parties that were joint tenants with me. All right? Now, are we clear on that? Yes? No? All right. Now that I've told you that, I lied to you. Joint tenants, there is a very, very difficult lawsuit called partitioning that can take place. I'm going to redraw the picture as a circle with four owners. So you got A, B, C, and D, right? Let me give you the backstory on what's going on. Grandfather dies, leaves the farm to the four brothers in the will. Got it at the same time. There are four of them. How much do they own? 5% each. They are on one title work, and they all are allowed to work on the farm. So Grandpa leaves the farm after he bought the farm. He left the farm. Okay. Grandpa leaves the farm to the kids as joint tenants with right of survivorship. Four brothers all own 25% of the property. One of the brothers is wacko and wants out. There is a legal battle called partitioning that would allow him to go in front of a judge and say, I don't want to be involved in this. I want my money and I want out, okay? Now, I will tell you there's a whole bunch of other things that would happen probably prior to this, and I know you guys are going to ask this question. The easiest would be for the three brothers to buy him and divide it three ways, but that doesn't allow me to explain this example, so that's not going to happen, okay? Yes, that would be the easiest, but that ain't what I'm talking about. The judge will determine, first of all, if partitioning would actually destroy the value of the property. He may not allow it, or he may force the entire sale and pay out all four of the brothers. That's another example that could happen. But for this, what he does is they would partition out his section and allow him to sell his 25% to perhaps the cousin that really wants to work on the farm, E. So you got Alan, Bob, Charlie, and David, sells it to Edward. That worked out really pretty good, actually. All right. Are we caught up with the story so far? Now, what's important to realize is brother A still joint tenants, and they continue to operate like joint tenants. So when one of them dies, his portion gets divided amongst the other two brothers, not the three brothers, because David partitioned his out. He doesn't play in the game anymore. All right? So how much do C and B own? Math, we need the math whizzes here. No? There's only two in the joint tenants. 37.5% each, right? Because once David partitioned his 25% out, the three that are left only own how much? 75%, right? So those three continue to participate. So what you have is one of them dies, there's two left, they divide the 75, it's 37.5%. Then one of them die, and what you're left with are two tenants. One owns 25%, right? Because he partitioned out. The other surviving brother owns 75%. What does that look like to you? What does this look like now? You got, huh? Somebody says Pac-Man. I get that all the time. You got two tenants that got the properties at, and now works. The only thing that possess is they're working on the farm. See a lot of different look. So again, yes, they are tenants in common. Everybody, look at it now. What does it look like? It looks exactly like tenants in common. What you have are two partners with disproportional shares. They got their properties at different times because David sold to Edward and he came in later. And because of that, they got different title work. The only thing they're sharing, the only unity they have is possession, which is the friggin' definition of tenants in common. Back up. What I'm telling you is this. After the partition court case, A, B, and C are still joint tenants, right? A, B, and C still work like joint tenants. But together, the three of them are a tenant in common with the partitioned one. I'll wait and let that sink in for a minute.
It's David's fault.
It's David's fault. So you got Alan, Bob, and Charlie still operate joint tenants with right of survivorship, but they only control 75%. But that group of three is a tenant in common with the new guy that bought David out. That's called partitioning. It's a very hard court case, and judges have trouble with it, and a lot of times judges will, first of all, most of the time in the real world, judges are going to go back to the three brothers and go, hey, why don't you just buy him out, make it a lot easier, all right? But there is that court case available for that scenario, right? Now, There is a very special joint tenants for married couple. It is called tenants by the entirety. A husband and wife have tenancy by the entirety, meaning in the real property world, husbands and wives own the property together as in one entity, so that when one dies, the other one still owns the property. Doesn't have to will it to them. No one can contest it. There's no probate, all of that. Remember yesterday, dower and courtesy rights? That's personal. Here we are with the real portion that we talked about is called tenants by the entirety. It is the real portion of that. Both parties should sign. So if I've got a house and I'm listing clients and the house is only in the husband's name, the mortgage is only in the husband's name, I still need both of them to sign the deed under this law because they're both owners. All right? A husband could go out and buy an investment piece of property. Don't tell my wife. That's fine. She still owns half under this law. All right? By the way, for those of you that are interested, this is one of the big arguments about the same-sex marriage. Because if they're married under the eyes of the law, they have this protection so that if one dies, the other is protected for the house. As opposed to friends living together, one dies, the other may lose the house because that other person is not protected under the tenants by the entirety since they're not married. All right? So this is one of the things that the same-sex marriage goes on. Personally, I think anybody should, I don't care, anybody can get married. Let anybody marry whoever they want to marry. For those of us that have been married, we all know that after a while it's the same sex anyway. All right, moving on. Separate and community properties. Is Indiana a separate state or a community state? I love this question because this is a question that if you've been divorced, you know. People know the answer to this. Indiana is what they call a separate property state. All right? What I'm telling you is this. While you're married and you go out and you buy a car, husband and wife both own the car because tenants by the entirety, the dowry and courtesy law, and all of that. But in a separate state, anything I bring to the marriage is mine after I bring it, after we get divorced. That was my property. That's not ours, that's mine. All right? So I owned my house, got married, got divorced. She had no right to the property. It was my house. I brought it to the marriage. That is a separate state. So anything you bring to the marriage is yours after the marriage. Anything that gets willed to one party also is not community property. That way it can stay in the family. So if you're married and like grandma willed the wife, a wedding dress, when you go to get divorced, that wedding dress would come out of the property and you go, no, that doesn't get split. That was willed to the wife. Well, we were married. Doesn't matter. Indiana's a separate state. Or anything you buy with money that you get from a will. So if your grandfather leaves you a bunch of money and you go out and buy a rental property, that rental property could be separate. All right? Because it bought with money from wills. So anything you bring to the marriage, anything that's willed to you, or anything that's bought from money that's willed to you.
So what happens if you weren't married and the husband had the house and then he dies? Does the wife get the house?
Potentially. He could have left it somewhere else.
Oh, so if he didn't leave it anywhere, it would just go to the wife?
She would have to petition the courts for it. And the judge would give it to her probably. But what I'm saying is if kids come in and go, no, that's our inheritance, we want that house to be sold. Was the house free and clear? Most people have questions because I've got a friend. Was the house free and clear in your example?
No, I'm talking about me and my husband. We weren't married when we bought the house. So it's only in his name.
Right.
And then we already had a kid, and then we bought the house, and then we got married.
Okay. Is there a mortgage on it? Okay. In the growth, and the key that I maybe I didn't make it clear, on my example, my house was free and clear. So, and I'm not a practicing attorney, all right? And family law is the worst law in the world there is. I'd rather be a public defender than a family attorney. Anything that has a growth in it, you're entitled to the growth, all right? So because you suffered by not getting the money because you guys were making a house payment, you see what I'm getting at? So half of the money you paid towards house payments while you were married, that's still yours, all right, even though the house isn't. Another good example that a lot of people have is, oh, I'm getting divorced, but I owned the lawn cutting business when I married my wife. I already owned that business. Yes, but when you owned the business 20 years ago, it was one lawnmower. Now you're getting divorced. It's 15 trucks and all of this. All of the growth between the one lawnmower and the 15, that's half hers, all right? So even though he bought the house, you're making house payments for 4, 5, 6 years. You get divorced. All of that house payment that you made with money he earned is half yours because you're married, or money you earned is half his. So if there's a mortgage on it when you make payments, there's some equity growth. That growth is part yours. All right? Do what? Can't create a law, can't create a will that supersedes state law. Indiana doesn't use prenuptials. Now, with things outside of the law, like, potentially business and stuff like that, but I can't, you're stealing my jokes from later chapters. If I die and I have a wife and a girlfriend, which is probably why you would die, I can't will my house to my girlfriend because state law under tenants by the entirety says my wife gets it. So I can't write a will that supersedes state law. State law is precedent.
Well, death is different than divorce, right?
Do what?
Death is different than divorce.
It doesn't matter. Even if I'm getting divorced, that's still half her property. That's tenants by the entirety. That's what it does. This law was created back when women were frail and had to be kept so that a husband couldn't, what, am I lying? I'm right. That's what this law was designed for. It was designed so that a man then, decided he was going to cast this wife to the side and get a new girlfriend and leave her penniless. No, she gets half the stuff that they accumulated while they were married. All right? Now, in the new age, it works both ways now.
So that goes to cars, too,
Cars?
doesn't
Yeah. It also goes for medical bills. When people get divorced and they go, oh, my wife had a bad back, she's got medical bills, we're getting divorced. Guess what? Those are still half yours.
Student debt, everything.
Student debt, anything. Anything you acquired while you were married. Because you guys are one unit. Now, if it was before, then no. That's because Indiana's a separate law, state. That's what I'm telling you. I owned my house free and clear. When I got divorced, she gets nothing of the house, packs her clothes, drives her car away, and that's it. House was mine, and it was free and clear. So there was no equity earned while we were married, because I owned all the equity. All right?
I knew someone who had a prenup and it worked out in their favor. In the state.
What, the prenup for what? Was it a prenup for a business or a prenup for a personal property or what?
He walked away with both homes.
She still had to pay him. Here in Indiana?
Yeah.
Guarantee it. Indiana's a separate state. And you can't write a will or a prenup.
He had to pay her like a certain amount of money that was accumulated on some sort of savings account maybe, but he didn't. She walked away free and clear, like she doesn't. She signed quitclaim deed to both the homes.
That has nothing to do with the mortgage. We haven't got to there yet. That's the biggest thing. You guys have the worst concept. He took her name off. That's what refinance does.
Right.
That's why she can walk away free and clear. Quitclaim deed off just gives away your rights to the property.
Right.
You're still on the mortgage. Those are two separate documents.
Right.
All right? A refinance is a sale with a repurchase. So that takes the new person off or the old person off. And I was waiting for one of you guys to say that because you're the one we're going to pick on then. Because most people will go, well, my friend owned the house, and when he got divorced, had to give the wife. The first question I ask is, did they refinance? Oh, yeah, they went through. Refinance is a repurchase. So if I'm single, let me give you the example. I owned the house free and clear. I got married to Kat. If I decided I needed some money and was going to go, say, get a home equity loan on the house and refinance the house, that refinance, I would have been married. Now she owns half the house because tenants by the entirety. So the refinance is when two people are on it and they refinance, one doesn't qualify on purpose, so the husband then buys the house again. Now the wife's gone. That's how you get a person off, is you refinance, because it's a legal sale with a repurchase. Or that's how you put a person on, by mistake. You could go down and quitclaim a person onto your house.
Oh, you can quitclaim them on?
Yes. Yeah, married couples do that a lot. That's what she needs to do back there, is to get ownership into that house, have her husband quitclaim to the new party of her husband and her name, and then record that, and now she has an ownership interest in the property. Huh? Not at all.
See, our realtor told us I did it. I shouldn't be on it when we bought it because we weren't married. And then we were going to get married.
Was your realtor a guy? Bros before. Oh, I'm sorry. Yeah.
But he was a first-time home buyer, and so he used that loan.
Were you a first-time home buyer? You already owned a home?
No, I never owned a home.
Okay. I don't know why couples can buy homes without being married. It's a violation of the Familia Act if they try.
Yeah, I didn't have any.
Yeah. Well, funny, they're kind of picky about that when they don't have money or credit, so that's usually a reason why you don't put someone on. But if he wants you on now, all you have to do is file a quitclaim deed, get it notarized, go down and record it. It's going to be about $13 or $15, and he'll put your name on the house, and now you have an ownership interest. I am not. It's amazing. All of the women in the class went, yes, it is, and all the guys are like, no, you don't really need to. Just trust him. Yes.
In the instance where, in that situation, the owner dies, I mean, she gets the house anyways.
No, not necessarily. Not necessarily. Because The question was, does he get the house necessarily if he dies? No, this is an example of, it's because Indiana's separate property, it's his house. Now, she would petition the court and say, I have a valid marriage, but let's assume for a minute he's got kids from a previous wife. Those kids could also say, no, that's our inheritance, we want some of that. All right? But like when my dad died, my mom automatically got the house. I can't go and say, I want half of that. No. Indiana has tenants by the entirety. Mom gets the whole house.
What if there's a mortgage?
Well, they still got to clear the mortgage.
So I guess that would the bank say you have to sell this, or we want money right now?
They could call the loan due. Yeah, we're in chapter 14, so
Contracts.
they could say we want the loan being called due and force her to sell the property if there's no equity. She could negotiate a deal with them to refinance it and put it in her name. Yeah, and put it in her name. Family law, trust me, I don't like family. Here, you know here's the funniest thing about family law. Do you realize that in Indiana, my children, and I just see the picture on Facebook where I dumped off Connor yesterday.
Yeah.
So I've got 6 kids. Some now are 18 or older. Under family law, I can totally write them out of the will. And they are my blood relatives. But yet, my wife, who I literally went, you cannot cheat. You can't write your wife out of a will because of that, because of the state law. So here you got family that's blood runs in them. You can cheat them. And some person you picked out of a lineup, let's face it, that's how you guys got married, right? You picked them out. At some point, you went, you'll do. You can't cheat that person. I've always thought that was weird. Now, kids under 18, I have a responsibility for. I still got 2 left at home. I have to take care of Olivia and Sean. But I could take Ian and Justin and Brandon and go, sorry, you're out. But Kelly automatically gets stuff because we're married. Well, a little more than you guys care to know. I'm on wife number 3, Kim, Kat, Kelly. And I dated Katie in between there. Yeah. But that does not top a buddy of mine whose first wife was Holly Marie, whose second wife was Holly Marie.
I know somebody like that too that had, yes.
He's got, so he calls them Holly 1 and Holly 2.
People guy who had 6 wives. Betty 1 and Betty 4.
Yeah. Could be like my uncle. My uncle had 4 wives. 3 of them were the same person.
Yeah, my mom did. My
Yeah.
bio dad, he was on number 7, but she was 3 times.
Yeah, my uncle married Aunt Barbara 3 times.
Don't get it either.
Married him, divorced, got married again, divorced, got married, and then died when he was married to Aunt Barbara. So he was married to the same woman. He had 4 wives. 3 of them were the same one. What's the definition of insanity? Doing the same thing over and over and expecting a different outcome. Community property, we've run this one way long. Community property, and there's only like 11 states in the nation. California, Wisconsin, and I don't even care to memorize the other. The second you say, I do, half goes to the other person. And if you guys are old enough to remember the Eddie Murphy routine, half, I get half. That's what community property means. Whatever you bring, boom. You get married, divorced, you get half the fortune of the other person. That's community property. That's where you start writing and you see prenuptials where they agree not to take something until you're vested in the marriage or something.
Yeah, I think he's got like a pension and inheritance and.
Yeah.
stuff like that. But did they get married?
That's curious. I know we did.
It won't work. It'll get, he can, hey,
She bought it and
she can sign it and do everything. I would find it hard to believe that it got overthrown.
he got everything yeah.
He either had a really good attorney or she had a really bad attorney.
I think it's both.
One of the two. Because I don't know how it could overwrite. One of the other things that's cool is the one difference, and I told you in a separate marriage, stuff I bring to the marriage, buddy of mine, well, Jeff, buddy of mine who is a practicing attorney had a court case, and I found out something I didn't realize, that the guy was hurt in a work injury, and the courts awarded him pain and suffering. That's also a separate payout. Pain and suffering is a separate payout. Wife's not entitled to that. Yeah. You got the conjugal claim that they can have, but pain and suffering is not community money. It was single money.
There's some other, I know my husband is pilot, only because our lawyers dug into this, but if he supposedly goes down and his plane and Southwest pays us, I actually don't get it unless he wills it to me.
Oh.
The kids will get it, I do not.
Yeah.
Because of the state that we live in, which I find funny.
Was that state of confusion?
And, yeah, I know. I'm like, really?
Are most states separate or community?
There's only 11 states that are community. Alaska is like on the border. You can negotiate. California, Wisconsin, I'm trying to remember. It's all those liberal states. No, Texas is not. I had a list of them at one time. I'll look them up for you and get them to you. There's only 11 of them. I thought I had those written down somewhere. Probably, I think I'm in my second teacher's edition book, and I wrote them down in the other one. Huh. All right, any questions?